What's up, William? How you doing tonight? How are we doing tonight? Same old shit. Same old shit. Working with this slow ass computer. I just imagine how much shit I could get done if I had a regular, not even, just like a computer from like 2010. I got off for the rest of the weekend. Well, I'm making my own hours, so. But I got off Friday, Saturday, Sunday. Alright, what was I trying to do here? Why does YouTube crack you up, Lucy? Alright, what are we doing here? I'm sure it's all of them. My middle fingers. Oh, I got you. So what we got here is 2018, I think. DUI for Steve G. And I got the body cam coming. I'll be right back. Well, first I'll put it down here so you guys can read while I'm at the bathroom. Alright, sorry, I'm back. Alright, what do we got here? So this was in 2018. Actually, the day before my birthday. At 8 o'clock at night. And it's for... Where the hell's the name at? Where the hell's it at? Steven Gonzalez. Or Goncalves. Surprised it doesn't say the person's name further up. And it's for a DUI. Alcohol or drugs. Observed alcohol or drugs. So we go down here. And the narrative on September 27th, 2018, I, Officer Kennedy, was on regular patrol in the city of Rathdrum, up southbound on Highway 4153 interchange, following a black 2000 Volkswagen Jetta bearing Idaho license plate. I can't read this shit. Okay. I saw the driver's side tail light of the Jetta was not illuminated. The passenger side tail light was illuminated. The time was approximately 8:23 p.m. and it was dark. The sun set approximately 6:33 p.m. that night. As we continued southbound towards the next intersection, the driver of the Jetta drove onto the yellow center line with his left side tires and swerved within his lane. I activated my overhead lights to initiate a traffic stop for violation of IC 49-906, which states every vehicle must have 2 working taillights after sunset. So, why you suspected the influence of drugs and alcohol? Right, the old you got a taillight out. Upon contacting the driver of the black Jetta, identified by his Idaho driver's license as Steven Goncalves, I recognized the odor of what I know through my training and experience to be that of an alcoholic beverage coming from within the vehicle. Steven was the only occupant. His movements were slow and deliberate. His memory appeared to be impaired, and his recognition of standard documents in his vehicle was labored and incorrect. I asked Steve how much he had to drink that night. He looked at me and just shook his head. I told Steven I could smell the odor of the alcohol coming from him. He told me, I don't want to lie, I had a drink. Well, at least he's not a liar. Well, back then he wasn't a liar. So, he gives them a field evaluation. During my initial questioning, Steve told me he was not under the care of a doctor. He claimed... What the hell was that? He claimed to be in good health and not taking prescription medication. I then explained and or demonstrated each evaluation to Steve prior to asking him to attempt them. Horizontal gaze. Not even going to try it. I hate that word. Stephen's eyes tracked the stimulus equally, but displayed a lack of smooth pursuit. His eyes displayed distinct and sustained whatever the fuck at maximum deviation. He also had that prior to 45 degrees off center. Stephen did not have vertical nystagmus. Walk and turn. He attempted this evaluation and was not successful in passing. He could not remain in the starting position without losing his balance and stepping out of the required position. Once he began, he missed several heel-to-toe steps and stepped offline several times. Stephen turned improperly. After turning, Stephen asked if he was supposed to walk back. I reminded him yes, that was what I instructed him to do. So he's probably pissy. He's probably hammered. I mean, it's only 8 o'clock at night, so how drunk could he be? Alright, where was I? Important. Oh, hold on. One leg stand. I attempted to explain this evaluation to Stephen. Stephen began before I finished the instructions. Once Stephen started the evaluation, he swayed and was unsteady. He put his foot down at about the count of 15, saying he just stopped because he did not know how long to go. I told him it was because I was explaining the evaluation to him, and he started before I was finished, even continuing after I told him not to start yet and to listen to the instructions. Stephen said, "My bad." Important evidence during arrest and transport. Stephen refused to provide evidentiary samples, chemical tests, and results. Steve refused to submit evidentiary testing. When I explained the collection process to him, he said he wanted to have his blood drawn instead of providing breath. I told him that that's not what we do normally. That's for felony DUI cases. When it came time to provide the breath samples, he again said he would only do blood because it was more accurate. I asked if he was going to refuse to provide breath. Stephen said he was not refusing. He just wanted to have his blood drawn. I reminded Stephen of the words in the ALS form I just read to him and stated, if you refuse to take or complete any of the offered tests pursuant to section whatever Idaho code, I told him I was offering the breath test to him. So he's like, fuck that, I want you to take my blood. It'll give me a little bit more time for the alcohol to get out of my system. Alright, where was it? Okay. Yes, this is for Steve G, the father. Stephen who sounds like an auditor. Okay. Stephen then wanted me to show him the ALS form and reread it to him. I showed him the above line and read it to him. Stephen then wanted me to reread the entire form to him, claiming I left out parts of it the first time. I told Stephen if he did not provide breath samples, he would be considered to have refused. Steve did not provide breath samples. My reading of the ALS form in its entirety was recorded on my view camera. So he was like, "No, I'm not doing that breath shit. You're not getting any of my breath." The things in the report. Messages and right. Okay. Yeah. I got you, Lucy. Okay. I think it just starts over now. Yeah. Okay. That's it. Is it important times? Time of stop. Evaluations. Actual arrest. Transport. Christ, he was arrested 10 seconds at less than 10 seconds after he got pulled over. He got stopped at 2022. He was arrested at 2039. Field sobriety tests are a trap. There's no way to pass them. Even if you do pass them, their judgment, and it's not always good judgment. Like, you could do exactly what the cop says, everything perfectly, the way he did it, and he's still gonna take you to jail. Excuse me. Anyone have a form, Resident Police Department. Filled out booking sheet, transported. Rescue breaths. What an F. Why is there two of them? Okay, one's the narrative. I don't get it. Oh, this isn't a double one. Hold on, this one's fucking confusing, bro. It's like the same, but it's not the same. I bet he was. Okay, one leg stand. Excuse me. Hey, Ariel. Why was he on probation? Excuse me. Okay, additional information. We read this. They were slow and see, they didn't say nothing about his eyes were red and glassy on the first one, in the first paragraph. His motions were slow and deliberate. Doesn't say nothing about his eyes up there. I don't care. Listen harder, Kane. What did Dylan say about what? No shit, Lucy. That's crazy. So this one says, "Hey, Edie." Yes. Exactly, Ariana. Who the hell's JJ? This is my fight song. This is Steve G. Senior. A DUI arrest. It's from 2018. Excuse me. Oh, he was on probation for this? He was on probation from damn, he got years of probation. No shit. That's crazy, Lucy. 16201. I don't know what case this is, but that's wild. Wow. He violated it. He's a grown ass man violating probation. Right, it don't make no difference, Lucy. You know what I mean? What the hell is blinking and driving mean? I don't know what that means. Alright, how about I got something you can read while I go get some chips. Here is 2022-2023 Sigma Chi roster. I'll be right back. Alright, I'm back. Sorry. What did I miss? There are a bunch of titty baby entitled assholes that have been brainwashed into thinking they are superior. Alright, who's on this thing? Cooper Atkinson? Barachoa? Kelvin Cobley? Deef Dayton? Conrad Harrison? Drew Giacomazi. Zach Ziegler. Huh. Right, 100% King. Zach Ziegler, yep. Yeah, it's crazy, ain't it? It's crazy once you think about it. Mason Mitsuri? Xander Dash. Hey, Agape. I can't get over. Where's the one? Dayton Deef. Hey, Mandy. Good old Dayton Deef. Alright, what else we got? Yes, Ariana. Excuse me. These are the drawings that Jack D did of the 1122 King Road. He had to draw a house, or he had to draw the layout of the house. I don't know what you do with it. I have no idea what the job description of a moderator is. I want to know why he drew the deck not all the way past Maddie's room. Well, we know Kane can do math. Yeah, I doubt that, Agave. What the hell is this supposed to be? Oh, the toilet, maybe? And here's Maddie's underage drinking report. So we got they were at they had to be at the Whites because they're at 701 Taylor Avenue. That's the Whites, right? Yeah, yep. We were just looking at that. It was back in 18, and Lucy said he was still on probation for it at the time of the murders. And we're gonna get that body cam too, from that report. Well, we're gonna try to get the body cam. Depends on how much it is. All right, and guess who arrested her for this underage drinking? Listen to this, you'll get a real kick out of this. 9/21/2019, at approximately 22:45, Officer Tesdall and I were on plainclothes alcohol emphasis detail in the area of Taylor Avenue. Ain't that crazy? So how long's he been doing plainclothes detail in that area? Yep. Yep. Now, I don't know about this, but I don't think there was body cam for this. I don't know. I'm talking about the Steve G DUI body cam. Right, exactly, Lucy. But what she does here is funny. It's hilarious. So, I saw a female walking near the 700 block of Taylor Avenue with an unopened 19-ounce White Claw. Officer Tesdale and I walked up to Mogan, displayed our badges, and identified ourselves. I asked Mogan how old she was. She told me she was 21. When I asked Mogan for her ID, she dropped the White Claw. She dropped the White Claw on the ground and started to walk away from me. I placed Mogan in handcuffs and told her she was being detained for an alcohol offense. Mogan admitted to only being 18, and I cited Mogan for minor in possession. We may have seen it. Scully's doing a like a tutorial kind of thing. She paid $487. No, not Rosie. It was just Tesdall. It was Tesdall and Snyder. And Sieverding and Peak. This was before Rosenthal's time. Quality Patrol. That's funny. Alright, what was I gonna look at? Oh, I got Bethany's accident reports. That's he wouldn't have had to do a video to put a thumbnail on it. Hey, I'm using my grandmother's 2005 Dell desktop. I had a nice laptop, but I think Lucy did some voodoo on my house or something. Yeah, literally. I wish it's not even a joke. Like, if I was gonna make up a joke, it would have definitely been funnier than that. Where is my shit? Oh shit. Starting to freeze up. What the hell am I doing? Alright. This computer does not like to use Google Drive. Not even a little bit. Don't everybody talk at once. Hey, when was Maddie's what you call it? Her minor in possession? Was that 9/1? Maddie get arrested on September 1st? I'm trying to figure that out. But I gotta have both. I gotta have StreamYard and OBS or something. I was actually looking that up yesterday. Hey, Rui. Say it. And just to remind everybody, we still are a little short on the FOIAs, and it's due tomorrow. Well, today. It's Friday, right? 1 o'clock. We got enough for the financials. There's 2 body cams. The frat fight. We have 3 more. And I think we need $73 for all 3 of them. Oh no, I don't want to do that. What is this thing doing? I don't remember seeing that. I don't remember if Bethany had a DUI. Alright, now open this. Where the hell did it go? Hell ain't here. I just fucking saved it. Well, we'll be doing that again. Hold on. Hey, Birdie. Well, I hate when I do this dumb shit. Dancing and sweating through this white t-shirt. Sounds like fun. Shit. Yeah, and one of the women were like, they don't want their kids to get involved in it or some shit. Oh no, what am I doing here? Alright, almost got it. You guys listen to me fucking cuss at myself more than anything, don't you? I used to like Tang. I don't really care for it anymore. What report was I just trying to get? Did I just bring up? I forgot what I was looking for. Dude, what the fuck? I just... here we go. That's all I had to do, right there. That's it. Imagine it. Whoa, okay, look at this now. This is something you don't see every day. Apparently, you can't fucking see it at all. Where the fuck? Where the fuck? Oh, where the fuck? Where the fuck? I don't know. Oh, Jesus Christ. What the fuck? I don't know how to make this screen on my screen. Can you guys see this? Or am I just a fucking idiot? I'm gonna take that as a yes. Okay, so this is the underage drinking that they didn't write the report up until 2025. You need their the names of the Banfield boys? Because we don't do no redactions around here. Why is my shit froze? Hold up. Hold up. Hold up. How received by radio? They got the call over the radio about these kids? I thought they just happened across them. If you watch the girls on the river float, man, lick her lips. Oh, up Kelly's uncle. What? I don't know what that means. But how the hell was this called in? Yeah, but this says the call was received. Responding officer, responsible officer, received by, how received. Okay, so they went, never mind. Sorry, I'm an idiot. Look at all the people that wanted this. Let's see if we know anybody. Yeah, they get the space between, but you don't. Oh, would you look at this? We were working a plainclothes alcohol enforcement emphasis. Same exact shit. Oh my God. One male fell down as he walked across Taylor Avenue. Holy shit. And this is Rosenthal's report. Rosenthal wrote this report. Nah, they never fall down. We don't see them fall down. They're across Banfield by the time we see them. All right, guys. You wanna? I'm going to bed. We're just gonna have to. I don't know. I was gonna stay live till we got the money, but I'm tired. Unless y'all want to watch the. You want to watch the hearings or what? I can put them on. You got kicked out of Idaho? How the hell you get kicked out of a state? Hey, January, I didn't even see you in here. How the hell do you get kicked out of a state? Alright, let's do this. I'll put on the, what you call it again? Y'all can stay here. This is my fight song. Oh, I don't give a fuck about them. They ain't paying my bills. Well, let's point it out. Looks like they're actually staying in one place, kicking someone in the ground. That's right. Yeah, I did watch that video. I'm not excited. Sometimes I can see shit in Rolo's videos, and sometimes I can't. Any particular one you want to watch?
Oh, we got it. We took care of it. Yep. You good. Okay. All right.
Please be seated. We are in the Second Judicial District, Latah County. This is the Magistrate's Division of District Court. This is State of Idaho versus
Dirk
Ryan
Diggler.
C. Kohlberger, cause number CR 29222805. Mr. Kohlberger is present in court. He is in custody. He is appearing with his attorney, Ms. Taylor. Mr.
Yeah,
Thompson
I heard
is
that-
attending
that-
on
yeah,
behalf of
him.
the state. This is the time set in the matter for initial appearance. Mr. Kohlberger,
You guys
I
hear
am going
this?
to advise you of the rights that you have in this case. I am going to go over the criminal complaint with you, and then we're going to discuss setting the matter for further hearing. You have the following rights. You have the right to remain silent. Anything you say can and will be used against you. You have the right to the presumption of innocence. That means the state
Did
bears
they?
the burden to prove that you are guilty of this offense beyond a reasonable doubt. You have the right to a preliminary hearing. A preliminary hearing is a probable cause hearing. At that hearing, the state must
What was she
establish
saying?
that more likely than not, these felony offenses were committed, and you were the one that committed the felony offenses. You have a right to have that hearing within 14 days if you remain in custody.
I
If you
must
are
have missed
bound
it.
over at that preliminary hearing to district court, if the court finds probable cause, you would be bound over to district court.
Well, I
And
guess
at
I can
that
let you
time,
watch
you can
the.
enter a plea of not guilty, and you can have a jury trial set within 6 months of your appearance in district court. At both your preliminary hearing and your jury trial, you have the right to
Watch
confront
the
and
stars
question
play
any evidence or
Beverly
witnesses called against
Hills.
you. Call witnesses on your own behalf and compel witnesses to be present and testify at the state's expense. You have the right to be represented by a lawyer. If you cannot afford one could be appointed to represent you based upon your financial need. You
That's
also have the
where
right
I
to appeal
wanna
any
be.
conviction in your case. Do you understand these rights?
Yes.
I am now going to go over the criminal complaint with you. Count 1 of the criminal complaint charges you with the felony offense of burglary. It alleges that the defendant, Ryan C. Kohlberger, on or about November 13th of 2022, in Latah County, state of Idaho,
Judge
did
reviewing
unlawfully
options
enter a
to
residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder in violation of Idaho Code 18-1401 and 1403. The maximum penalty for that offense, if you plead guilty or are found guilty, is not less than 1 year in prison, no more than 10 years in prison, and or a $50,000 fine or both. Do you understand?
Yes.
Count 2 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Ryan C. Kohlberger, on or about November 13th, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought.
You wanted to change it, please? Is that what you want to watch? Is that what you mean?
Stabbing Madison Mogan, from which she died, in violation of Idaho Code 18-4001, 4002, 4003, and 4004. The maximum penalty for this offense, if you were to plead guilty or be found guilty, is death or imprisonment.
Hey,
for
what's up,
life.
Amy?
Do you understand?
Yes.
Count 3 alleges that you committed the felony offense of murder in the first degree. It alleges that the defendant, Ryan C. Kohlberger, on or about November 13th of 2022 in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Kaylee Gonsalves, a a human being, by stabbing Kaylee Gonsalves, from which she died. In violation of Idaho Code 18-4001, 4002,
What the hell is
4003,
CC?
4004. Again, the maximum penalty for that offense, if you plead guilty or are found guilty, is death and/or imprisonment for
I
life.
don't know what CC
Do you
means.
understand?
Yes.
Count 4 alleges that you committed the felony offense of murder in the first degree.
Oh.
It alleges that the
I know
defendant,
what
Ryan
CC
C.
means.
Koberger, on or about November 13th of 2022 in Latah County, Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Xana Kernodle, a human
Not
being,
much,
by
just,
stabbing Xana Kernodle, from which she died.
Listen to
In
Kane.
violation of Idaho Code 18-4001,
I think Kane's
4002,
alternate channel is
4003,
the
and
pissy pants, the
4004.
pissy pajamas
Again,
channel.
the maximum penalty for that offense, if you plead guilty or are found guilty, is up to death and/or imprisonment for life. Do you understand?
Nothing.
Yes.
Really up.
Count 5
About to go
alleges
to
that you
bed.
committed the felony
Just wanna
offense
over some
of
shit.
murder in the first degree. It alleges that the defendant, Brian C. Koberger, on or about November 13th of 2022 in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. In violation of Idaho Codes 18-4001.
Hey, I'm about to go to bed, that's why I put these on.
4003 and
I'm
4004.
ready to go lay down.
And again, the maximum penalty for this offense, if you plead guilty
know this
or are
man?
found guilty, is up to death and imprisonment for life. Do you understand?
Yes.
And Mr. Koberger, would you like to represent yourself, hire a lawyer, or see if you qualify for court-appointed counsel?
I have court-appointed counsel.
Court has reviewed your application for attorney at public expense. I do find that you are indigent and do qualify for court-appointed counsel.
Yeah,
I
it
will
is.
appoint Ms. Taylor to represent you in this case. Ms. Taylor, have you had an opportunity to speak with Mr. Koberger about speedy preliminary hearing and setting this matter?
Your Honor, I have, we would ask the court to set the status.
Yeah, we're just gonna waive everything, you know,
To
and
make a final determination.
just send Brian right to jail.
And Mr.
Don't pass
Thompson,
go.
Ms. Jennings are in agreement with that.
That's fine with the state.
And pay restitution to everybody.
I will go ahead and set this matter for a status hearing then on the calendar on
That's true, Amy. I didn't even think about that.
January 12th.
Alright guys, I'm going to bed.
At 10 o'clock a.m. We will make sure notice is sent, and then, Ms. Taylor, do you wish to argue bail at this time?
Your Honor, I would like to ask the court to consider setting a bond.
Huge red flag. Huge red flag.
But it's a limited request as I don't have enough information. We are new to the case. We haven't reviewed
Not just
very much in the way.
not
of-
medium-sized red flag.
and
Like,
we just
huge.
work on the case.
The biggest they got.
We want the court to know that Mr. Koberger has a good family that stands behind him.
And
It's all
Mr.
on the
Thompson.
floor.
You know, the state's position.
This is prior to Hitler.
It's not entitled
This is
to
before the change of venue.
charges, as is noted.
This was
Arrest warrant.
2023. Hey, what's up, Sarah?
Idaho Code 19-816, 19-2903 both specify that given the potential penalties in this case, there's no right to bail. Bennett was arrested 3,000 miles away across the country, where his family is. We ask that he remain in custody. No bail.
At this point in time, pursuant to Idaho Criminal Rule 46B and Idaho Code 19-816 and 2903, I am going to leave
Thank you,
bail set in
January.
this case as no bail at this point in time until I have additional or further information at a later date and time. So with that, then Mr. Koberger, you will be remanded in custody and remain in custody on the no bail pending further proceedings in this.
What's that? What's Spokio
Is there
search limit?
anything further in the case then for today, Mr. Thompson?
Yes, Your Honor. The state is asking for no contact orders for various family members of the deceased and also for the surviving roommates. I've spoken briefly with Ms. Taylor. She indicated there's no objection.
And Ms. Taylor, is that correct?
That is correct, Your Honor.
So I will go ahead and issue those no contact orders. So I do have a no contact order then for
Oh shit, I thought it was John Joe. I don't know what the hell I was
the
thinking.
named individual of Dylan Mortensen, Bethany Funk, as well as the family members and Mr. Chapin, the family members of Ms. Kernodle.
Yeah, definitely.
Excuse me. Yes, Mr. and Ms. Laramie, Mr. Mogan, Ms. Cheeley, and then a number of members of the Gonsalves family. Those specific names will certainly be provided to you, Mr. Koberger, by way of being provided notice of these documents. You'll get a copy of these no contact orders. What you do need to be advised of and what will be in this no contact order is you are prohibited from having any contact with them whatsoever. You cannot contact them through third person in writing or by any electronic means. You cannot Facebook, Snapchat, Twitter, Instagram, use the phone to communicate with them or otherwise any form of communication in direct or indirectly with them. You cannot engage in any conduct that would harass, stalk, threaten, use, attempt to use, or threaten to use any physical force or violence upon them, or place them in reasonable fear of bodily injury.
We just got somebody just donated on Cash App. I'm not gonna put their name out there. I don't know their YouTube, whatever, their YouTube handle, channel name, or whatever. But thank you. All the red flags, Ariana. So thank you for that. We need I think we're at 50. We need 55 now. 55. Yeah, I think so. Or 53. 53, 47, something like that. I'm too tired to add. Thank you.
Cannot go within or knowingly remain within 300 feet of their person or their home, workplace, or any other place where they might be. There are no exceptions to these orders, and if you do violate these orders, it is a new misdemeanor offense. It is punishable by up to a year in jail and or a $1,000 fine or both. At this point in time, due to being in the magistrate's division here, at this juncture, I am going to issue the no contact orders for a period of 2 years, and then if it needs to be modified or changed by additional judge, it can be done so at that time. Is there anything further, Mr. Thompson?
No, Your Honor.
Anything further, Ms. Taylor?
No, Your Honor.
All right, thank you. We are adjourned.
All right.
Right, good morning. We are on the record. 29222805. This is State of Idaho versus Brian Koberger. Mr. Koberger is in custody. He is appearing here in court with his attorneys, Ms. Taylor, Mr. Logsdon. Mr. Thompson, Ms. Jennings appearing on behalf of the state. This is the time set in the matter for the preliminary hearing status conference. So I am going to inquire of counsel. Ms. Taylor, what's the status at this time?
Thank you, Your Honor. We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Koberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
And Mr. Thompson, are you in agreement with that?
The state has no objection to that, Your Honor. Ms. Taylor reached out to us by email yesterday with her proposal. On reflection, the state's calendar would be better in the month of July, but we will make the end of June work if that's the court's preference. And I haven't had a chance to talk to Ms. Taylor about that. I'm sorry, I know that's last minute.
That's okay. The court's calendar is going to be better towards the end of June, early July. So would that work, Ms. Taylor, for your scheduling on your other matters?
Your Honor, yes. If we take that 4th week in June, that's actually best.
Okay. So, Mr. Koberger, I need to speak to you for a moment then. Sir, you do understand, and Ms. Taylor has represented here, that she's advised you of your right to have, or fully discussed with you, the right that you have, which is to have your preliminary hearing within 14 days of the date that you initially appeared before this court. As you recall, when I advised you of your rights, that hearing is a probable cause hearing where the state has to establish that more likely than not, these felony offenses were committed and you were the one that committed the felony offenses. If you waive your right to a speedy preliminary hearing, it does not mean that you're giving up your right to have a preliminary hearing. It simply means that you would not be able to come back and challenge that the state did not present probable cause within 14 days. Do you understand?
Yes.
Have you had enough time to speak with Ms. Taylor about your decision to waive your right to a speedy preliminary hearing?
Yes.
Do you need any additional time to do so?
No.
Then I will ask at this time, as to the 5 counts, felony counts that were charged in the criminal complaint that was filed on December 29th of 2022, are you waiving your right to a speedy preliminary hearing and agreeing that that hearing can be held outside the 14-day period?
Yes.
And Ms. Taylor, do you concur with his waiver?
I do, Your Honor. Thank you.
I will find your waiver of speedy preliminary hearing is knowing, intelligently, voluntarily entered here in open court with the assistance of counsel. We will go ahead and set the matter for preliminary hearing. Beginning Monday, June 26th at 9:00 a.m. And I will go ahead and reserve the week, so June 26th to June 30th, in the event that we need all 5 days for presentation of evidence. And just so council knows, it will begin at 9 a.m. each of those days. Is there anything further to address at this time in the case, Mr. Thompson?
Not from the state's perspective, Your Honor, no.
All right. Or Ms. Taylor?
No, Your Honor. Thank you.
Okay. Mr. Koberger, then you will be remanded into custody on your same no bail at this point in time, pending further proceedings. Again, we'll send notice out to council, and we will be in recess for this morning.
Thank you, Your Honor.
Thank you.
All rise. Thanks very much. Please be seated. Good morning, everybody. We have some people on Zoom here too, so we're gonna hide it. Okay, let's get on the record, please. Thank you. Okay, we are now on the record in State of Idaho versus Brian C. Koberger, CR 29222803. Mr. Koberger is in the courtroom along with his attorney, Ms. Taylor. I believe also part of the team is Jay Logston and Elisa Massa, who is participating by Zoom, I believe. The state is represented by Mr. Thompson, Lake County Prosecutor's Office, or Prosecuting Attorney. Ms. Jennings is of that office too, Lake County Prosecutor's Office. Also part of that team is Ingrid Beatty and Jeff Nye, both from the Idaho Attorney General's Office. I'm John Judge. If you don't know me, I'm the Lake County District Judge, and I'll be presiding over this case. So, Mr. Koberger, you've already heard a lot of what I'm going to tell you at your initial appearance, but I'll repeat it to you because it's important, and I want to remind you of these issues. So I'll briefly cover your rights, the charges against you, and the maximum penalties if you are found guilty or if you plead guilty. So I'm going to start with the rights. You have a constitutional right to have an attorney represent you throughout these proceedings. If you cannot afford to hire a lawyer, then one is appointed at public expense. Ms. Taylor and her team have already been appointed, so that's taken care of. You have a right to a speedy and public jury trial where the state would be required to prove every element of each charge against you beyond a reasonable doubt. At that trial, you would have the right to cross-examine the witnesses called against you. That means to see, hear, and question them, to call witnesses to testify for you, and if you choose to testify in your own defense. But you're not required to testify because you also have a right of silence. That right is protected under the Idaho and federal constitutions, so you can remain silent throughout these court proceedings, and that can't be held against you in any way. What you do need to remember, though, is that anything you do say other than to your lawyers could be used against you in a later court proceeding. Do you understand that? Yes, I do.
Okay, thank you. You also have a right to appeal any final decision of the court. In order to exercise that right, you need to file a notice of appeal within 42 days of that final decision, or that right is waived. Also, if you are not a United States citizen, any finding of guilt in this state could have adverse consequences to your legal status. Do you understand these rights?
Yes.
Any questions about the rights?
No.
All right. Thank you, Mr. Carter. So let's go to the indictment. Do you have a copy of the indictment in front of you?
Yes.
Okay, thank you. And you see in the heading your name there. Is that your correctly spelled complete name?
Yes, it is.
Is that the correct birth date underneath your name?
Yes.
Are those the correct last 4 digits of your social security number?
Yes.
All right, thank you. All right, I'm going to read you the charges on the indictment, starting with count 1, burglary. That is a felony under Idaho Code Section 18-1401.
and 1403. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did unlawfully enter a residence located at 1122 King Road, Moscow, with the intent to commit the felony crime of murder. Count 2, murder in the first degree. That is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. Count 3, murder in the first degree, a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Kayla Gonsalves, a human being, by stabbing Kayla Gonsalves, from which she died. Count 4, murder in the first degree. That's a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. Alleging that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Zaina Kernodle, excuse me. This is hard, I'm sorry. Zaina Kernodle, a human being, by stabbing Zaina Kernodle, from which she died. Count 5, murder in the first degree. This is a felony under Idaho Code Section 18-4001, 4002, 4003, and 4004. This alleges that you, on or about November 13, 2022, in Latah County, state of Idaho, did willfully, unlawfully, deliberately, with premeditation and with malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing Ethan Chapin, from which he died. This was signed on May 16, 2023 by the presiding grand juror. So now I'm going to go to the maximum penalties of each charge, starting with count 1, burglary, minimum 1 year, up to 10 years in imprisonment, fine of up to $50,000 or both fine and imprisonment, restitution for the victim's economic losses resulting from the crime. For counts 2, 3, 4, and 5, murder in the first degree, maximum penalties, life in prison or the death penalty. Fine of up to $50,000 or both fine and life in prison or the death penalty. Restitution for the victim's economic losses resulting from the crime. Also, additional fine of up to $5,000 to be paid directly to the victim's family. If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties, fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes. Okay. Kohlberger, do you understand the charge in count 1, burglary?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 2, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 3, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 4, murder in the first degree?
Yes.
Do you understand the maximum penalty?
Yes.
Do you understand the charge in count 5, murder in the
Yes.
first degree? Do you understand the maximum penalty?
Yes.
And Ms. Taylor, is Mr. Koberger prepared to plead to these charges?
Your Honor, we will be standing silent.
And because Mr. Koberger is standing silent, I'm going to enter not guilty pleas on each charge, counts 1, 2, 3, 4, and 5. Now, at this juncture, the state has 60 days to give notice of intention to seek the death penalty. And Mr. Koberger has a constitutional and statutory right to a speedy trial. So let's start with you, Ms. Taylor, and then Mr. Thompson to discuss some scheduling.
Your Honor, would ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
Okay. Count it out, and that would be.
I have not counted it out, Your Honor, but I believe it would be about November 22nd of this month. Maybe November, somewhere around there. So I'd ask the court to set it for an October trial date.
How long do you think it'll take to try to case?
My best guess is it would take at least 4 weeks, maybe 6.
So you'd like me to set this for a 6-week trial?
At this point, I would, Your Honor.
And to do so, I will have to get rid of some of the other jury trials I have, but this is more critical and more important. So, Mr. Thompson, what's your...
Those trial dates are workable for the state judge.
About October 2nd, it started. Okay, for 6 weeks.
Yes, sir.
Anything else we need to address today, Ms. Taylor?
Not with regard to the trial setting, Your Honor.
Anything else?
No.
Thank you. Counsel?
Nothing for the state at this time, Your Honor.
All right. So with that, by the way, I do want to let everybody know, if they don't already know this, that once the grand jury issued the indictment, the preliminary hearing scheduled to start on June 26th was no longer needed and was vacated. So some people are confused about that. So I thank counsel, and I the media and the public for your attention and respect. So we are adjourned. Thank you.
All rise.
Thank you very much. Please be seated. When you're ready. And I'll be right back. At ease. Thank you. Okay, please be seated. Thank you. Here. All right, this hybrid approach is challenging. Okay, so let's get on the record, please. We are now on the record. This is State versus Brian Koberger, CR 29222805. We're here for a hearing on the Gonzalez family's motion to appeal, amend, and/or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine. They did. And this morning we have the state represented by Mr. Thompson and Mr. Rudley. Mr. Koberger is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is, there he is.
Let me sit back here, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Gonzalez family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Zayna's name. And I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Koberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Koberger's right. And under Rule 11A1 of the Idaho Criminal Rules, this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
If you allow me just a minute or two to get started out here.
take your
Appreciate
time.
it.
Take your time. Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense and all attorneys for the witnesses. when she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as, if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared, but only having a 3-hour notice did allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed the motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case, and the victims' families are not a party to the case. That's very clear through all of the case law, as well as...
Can I interrupt you?
Yes.
There's no dispute about that.
Okay, then
your clients are not parties. The only parties of this case are the state and Mr. Koberger. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tapp case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahunty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Flop was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case, and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me, because I'm not involved in the litigation. She also says...
Can I ask you a question about
Yep.
that? Because, I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
And I can
issue
address that,
right
Your
there.
Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes, because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, which witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that if the victims can say whatever they want during the free speech, and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, I'll give you an example.
I mean, is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting when we
We're
have.
not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I ask for clarification, now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, my victim, the family asked, has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion? Right? Well, then I'm already governed by the Idaho Rules of Professional Conduct. And if
I'm glad you're acknowledging that.
No, well, every attorney is, Your Honor. I mean, it's not.
Thank you.
Every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the trial publicity. But the trial publicity I don't even think applies to me. in this anyway. Because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews, so I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that? That they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so, me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way, it's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial.
And the other thing,
well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. Now, that is not post-conviction technically, is it?
Well, if your goal is fair and impartial jury, right, that's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. I mean, this hearing is about.
And as an officer of the court, I can tell you we have 0 access
Okay, so you're saying that the prosecutor's office has not shared information with your client?
Regarding the facts of this case, no, they haven't.
All right.
How things occurred.
And everybody's gonna have a chance to weigh in on this, and I just, you're helping me understand what the issues are, so thank you.
Well, so that's really the issue here. I mean, and this is an important ruling, because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that, part of the argument is that,
In fact, I know I have the authority to do that.
well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay,
So
that's hard to accept, but.
We're not witnesses in the case, we're not involved in the investigation, we're not involved in the litigation. I can't file any motions, I can't subpoena anybody, I can't cross-examine witnesses, I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is,
We're talking about your
That's right.
speech.
That's right.
Not your client's speech.
but that is my
That's a
speech, that is part of it though.
Well, in your memorandum, you are suggesting that you also have an independent position that you are representing yourself.
I do.
It's distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said we thought the judge was crazy, and I said the judge was crazy, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice, where I said the judge is crazy, yeah, I think the judge is crazy. That goes into another layer, right? Where Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the trial publicity. I would argue that I don't, because I'm not a party to it. I'm not litigated it, I don't have any information on it, none of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, and they interview him, they say, hey, you're an attorney here, what about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him in contempt of court? You can't. Same as me, because I'm not a party to it, he's not a party to it. He might be governed by the Idaho rules of professional conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this, what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I could go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, I mean, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for your honor? I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us, we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked out, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they've never interviewed us. So, they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Good.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Rutherford.
It'll be me. Can I have one moment, Your Honor?
Certainly. Thank you.
If I may,
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we provided no information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you.
If I could speak to that, Your Honor.
You'll be able to
Thank
come
you.
back in after you hear the other
Thank
arguments. Mr. Rutherford, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Gray's repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonsalves families are potential witnesses in a trial, or more specifically, at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like, to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. And with that, I'll stand for questions.
Thank you, Mr. Redley. Yeah, do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
All right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, quick here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Evans.
Thank you.
Mr. Elias?
Judge, I think a lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case, and therefore don't fall into 3.6, it would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you would fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just do they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to whip the media into a frenzy and send this case to the firing squad or probably something like that. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed. Thank you.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victims' families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is, everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in the court right now.
Because you're the one that brought me in here because of the non-dissemination.
You brought yourself in.
Yeah, well,
You're the one who filed the motion.
I did file a motion because the non-dissemination order is
I
unconstitutional.
understand. I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed, because I won't have the authority to file any other motions on anything else in this case.
Why would you say that?
Well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once again,
But
they're not.
well, the Supreme Court has said they have standing to come into the court and address issues, so.
Yeah, but that's completely separate. They're not.
Well, I know it's separate. But
Okay, so.
I also respect your position in representing the family's victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. They had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it would hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this. In the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way. And they've never taken us up on it. And maybe a random email here and there that says something and no follow-up whatsoever about anything. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Betke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between the
That's
state and Mr. Koberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're not a
judge.
party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties.
So-
As you've correctly stated who the parties are.
So we would
I
ask,
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
why would they
That's what you
claim?
just said.
I do think that part of the, that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
Okay, when you say they, you mean the prosecutor's
Yes.
office?
Yes.
All right.
Do you want me to give you a final, or do you?
Go find
Okay,
it. You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right that I'm governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct, because I'm not litigating it or party to the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Okay, thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today, and I'll get back to work and try to get a decision out as soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
I don't believe so, Your Honor.
Ms. Taylor? Mr. Watson? Anything else?
Yeah, Your Honor, we thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Thank you.
It remains in place until I address it. So, with that, we are adjourned. Thank you all. Yeah, see you in a bit. All rise. Thank you very much. Please be seated. Good afternoon, everybody. Okay, let's get on the record, please. Thank you. Okay, we're on the record. This is State of Idaho versus Brian Koberger. Case number CR 29222805. Mr. Koberger is in the court. He is represented by Ms. Taylor, Mr. Lobston, and Ms. Massett. The state is represented by Mr. Thompson and Ms. Jennings, also Mr. Nye and Ms. Beatty. And we're here for some motions, discussions, and before we get there, I want to address, really everybody, about the revised amended dissemination order. Apparently there's some misunderstanding about who it applies to and who it doesn't apply to. Because what I thought, and this is 100% my responsibility, I used the term agents, and the revised order says that the prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys are affected by this order.
Apparently, some of the media interpreted that as it doesn't apply to law enforcement, but it does. So law enforcement is, they are agents of the prosecuting attorneys. Now, I'm going to issue another order, another revised order, just to make sure that that is clear, because people seem to be very confused about that. Agent, definition of an agent is one that acts or has the power or authority to act. Another definition is one empowered to act for or represent another. So I'm going to include law enforcement for the prosecuting attorney's agents, and for the defense attorneys, investigators. So it's clear. I think it's sort of doubling down on the definition, but apparently that's necessary. I'm also going to add retained expert witnesses for each side, because we don't want to have a trial in the media or in the public. We want it to be in the courtroom. Speaking of that, a comment on the cameras. They're in the courtroom now, and I have deferred my decision about cameras. One of the things that's going to be really important, that is very important, is that the people with the camera and media need to follow the rules. And we've had some issues where people were pushing the envelope, particularly focusing on the tables where counsel sits. You are not to turn your cameras toward the top of those tables. And if you do that, you're probably going to have to leave the courtroom. Also, one of the things that happened in the Daybell case is that the cameras just continued to focus on the defendant. Don't do that. That's what brought the cameras to have to leave the courtroom in that case. And what I would prefer, if you want to continue to have cameras in this courtroom, is to back off and not, do we have that? Yeah, make sure that's muted. Make sure that we just have the totality of what is happening in the court, and not just focus, for example, on Mr. Koberger's face. So that was what happened in that case, and it's not appropriate. One other reminder to counsel, speak, and this is to myself, to speak into the microphone so we can have a good record. All right, I think those are my general announcements or cautions, and I think we've sort of boiled things down to some issues on motion to compel discovery. Some of those issues have been resolved, some have not. So let me go to you, Ms. Taylor, to start off. Where do we start?
Your Honor, we would request that we start on defendant's motion to compel and second motion to compel. I believe the third motion to compel will be heard on a different date.
True.
As it relates to the two motions to compel, and I'll present my arguments whenever the court's ready, but I can direct the court exactly to the numbers in those motions to compel that are still up for discussion today and request approval from the court.
Excellent. I'm ready.
On the original motion to compel, we are only seeking the court to order number 6 be complied with in that particular motion.
Okay, let me take a look at that. Number 6, and so this is the motion to compel discovery that was filed on May 4th.
Yes, Your Honor, that's correct.
Number 6. And that is request number 160.
That is for request number 160, and that was in the second supplemental discovery request.
Okay, thank you. All right. And we're getting, is that me? Okay. Number 6. for
Number
May
6
4th.
on that one, yes. On the
Okay.
second motion to compel, Your Honor, we are leading the court to order on request number 1, number 4, number 5, and I think that we have a plan for the other numbers, so those would be the 3 we need to court order on.
Thank you. Let me make sure I'm looking at the same page. Okay, number 1 is request 1. Number 4 is request 23.
I'm sorry, Your Honor, it's number 2, request 4.
Okay, I apologize. Number 2, request 4. Okay. And you said number 5?
And number 5, which is request 109.
Thank you. All right. And that's the second motion to compel discovery.
Correct.
All right. Do you want to make an argument about those?
I would like to.
Okay, go ahead.
Thank you. Your Honor, first, I want to start with talking about the discovery process. As the court knows, we have been representing Mr. Koberger since the very end of December of 2022. And during the course of the last several months, there has been a lot of discovery that's been requested and a lot that's been supplied. I come here asking the court to compel discovery. I'm seeking an order directing that we receive this discovery. I'm not seeking any other kind of sanction. I don't come here saying that the prosecutor has done something wrong. I come here saying that there are things that we have a disagreement about whether I should get them or when I should get them, and we seek a court order to assist us in this regard. Yesterday, we filed an exhibit that related to our motions to compel, and the purpose of that exhibit was to show the court how the discovery is coming in and what we are weeding through to try to find the information, and to let the court know that our office is making extraordinary efforts. Mr. Koberger's team works nonstop, and when we ask for discovery, it's because we have reason to believe it exists. So I wanted the court of counsel to be aware it's not a fishing expedition. These are real items that are really necessary to investigate this case and prepare Mr. Koberger's defense. So with that as the background and the frequent communication with the prosecutor's office to try to obtain the materials we need, we have come to an impasse in a few areas, and that's what brings us to court today. As the court knows, discovery is governed by statute 1309 and Idaho Criminal Rule 16. And the purpose of discovery is really to prevent an unfair trial, to prevent trial by surprise, and also to protect a charged person's rights to meet their defense. It protects their Sixth Amendment rights to have a sufficient and a prepared counsel, I should say, as we have a duty to investigate the case. So in preparing our case for Mr. Koberger, we've asked for several things that we still need. I'll talk first about request number 6 in the first motion to compel, and that stems from discovery request 160. It's training records. These are training records of 3 specific police officers. Your Honor, we have not asked for training records for every officer that has had anything to do with the case. I would not want to stand here and let the court think that this is an exhaustive list of the officers that we might need training records for. But these are 3 officers that we've requested them for, and the state has indicated they're not willing to give us their training records. These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations. We seek their training records to understand their processes. The training records, Your Honor, they are records that we've been able to obtain from various police agencies in the past. In this circumstance, are not records that I can find on my own. These are not things that are on the internet. They're not going to just hand them over to me. The two of the officers that we've requested them about are Idaho State Police officers. I have often received training records for Idaho State Police officers in the preparation of other cases during the course of my career. They are imperative for us to understand the specialty in interrogating and interviewing people, and for making the decisions that they made with regard to things taken as evidence in the case, or things followed up on or not followed up on. That is the purpose for those records, and we're asking the court to order the state to provide the training records for those 3 officers. Moving on then to our second motion to compel, and what we are looking for is a lot of information from the FBI CAST team, as well as the FBI forensic examiner team. What we're talking about here is the CAST team are the FBI examiners that use cell phone records to provide a lot of information that found its way into the probable cause affidavit that the state relied on in arresting Mr. Kohberger. I had the opportunity to meet with the prosecutor, and they indicate that we will be getting those items in number 1 and number 6 disclosed to us, but we don't know when. So I'm asking this court to issue an order with a date certain to obtain those records. These are bits of investigation that the FBI conducted that relate to Mr. Kohberger's cell phone, and the state has relied on that in their affidavit to say that Mr. Kohberger was in certain places at certain times. So these are bits of information and analysis that's been done since December. We are now at the end of June. We do not have those records yet, Your Honor. They are something that's been relied upon by the state for the PC affidavit to arrest Mr. Kohberger, as well as to obtain a variety of search warrants. It's information that the state has agreed we should have, so we ask the court for an order with a deadline to get that. I want the court to know I don't think that Mr. Thompson or Ms. Jennings are trying to withhold this. I think they'll give it to me when they have it, but I think an order from the court saying this is the date certain may help them get the information a little bit more rapidly. I'll move on to our last request, and that's number 2 in the second motion to compel, request number 4. And that has to do with the FBI forensic examiner that told the state to look for a white Hyundai Elantra. This is the examiner that originally there were certain years looked for, and that year range was expanded. I believe I have the communications between the police department and the FBI about how that date range changed, but what I don't have is the report from the examiner. I did receive the CD, curriculum vitae, from about the examiner late yesterday from the prosecutor's office, so I'm asking the court to order a deadline for the report to be given to the defense. Again, the court's read the probable cause affidavit that led to Mr. Kohberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Kohberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with a deadline so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense. As the court is aware that not producing discovery, especially when it's material, can be a due process violation. And as the court is aware, the state has filed its notice of intent to seek death against Mr. Koberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Koberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a heightened standard now that the state has filed its notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us.
Mr. Thompson or Ms. Jennings? Ms. Jennings.
So, Ms. Taylor's correct. She has everything that the state has in our possession. And we have worked diligently and consistently in getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio and video information. So we are down to just a few points of disagreement.
Sorry, my, a little closer to the mic.
Is it okay if I say?
Yes, yeah, that's fine, thank you.
First, with regard to item number 6 on the defendant's first motion to compel discovery. This involves training records of a couple of officers. Again, these are officers who the state would argue are not material to the case. They've interviewed other witnesses. They wouldn't even be called by the state to testify at trial. And the state objects to this because training records of specified officers aren't included within Rule 16. And they haven't offered any reason as to why this would be needed for the preparation of their case. Again, these are investigators who have gone out and just interviewed some witnesses within the case. So we'd ask that you rule that this is outside Rule 16. And I would just remind the court that several hundred investigators have been involved in this case. Our concern with allowing training records for these few, which we can't understand why there's a substantial need for these particular ones, wouldn't open the door to us then having to go and obtain training records for these hundreds of investigative officers who've been involved, some of which are outside of our control. Moving on to the second motion to compel. As to item number 1, regarding cast information. Ms. Taylor has everything that we have. I've also, that includes reports from MPD officers. What she is seeking is a specific report from the FBI cast team, which I have indicated to her is in its final stages of review. And we are anticipating receiving sooner rather than later, and as soon as we do, we will turn that over.
What's sooner than later?
Well, I don't have a date certain, but within the next few weeks.
I think Ms. Taylor wants a date.
I don't have a
If I'm
date.
not mistaken.
I have asked for a date, but that is not how the federal bureaucracy works.
That's, how about we say something like July 14th, unless there's some reason that they can't get that to you.
No objection.
Is that what you, Ms. Taylor?
Yes, Your Honor.
And then the state has substantially complied with request number 4, which is the same types of information, but related to the identification of the vehicle. Would ask for the exact same date certain of July 14th, only to obtain if there is one, a potential report that's outstanding.
Okay. Is that acceptable, Ms. Taylor?
Yes, Your Honor.
Again, I mean, if there's some itch in that, I mean, we can explore that, see what we can do to fix it.
Nothing further, I
Is
think
that
that
it?
takes care of everything.
Thank you, Ms. Jennings. Anything to respond to, Ms. Taylor?
Yes, Your Honor. I want to be heard a little bit more on the police training records. I am aware that over 120 officers were involved in the investigation in this case. I am not asking for all 120 officers. I will tell the court that likely there are other officers' training records that I will want. This is within Idaho Criminal Rule 16. These are records, documents, and objects that may have information relevant to Mr. Koberger's investigation and defense. These are records that are likely of witnesses. Whether or not the state calls them, they are likely to be witnesses. The three that I'm asking for now, they had critical roles at various stages. One of the officers did a Spillman search for 2011 to 2013 on bail entries to give to the FBI to look through these. One of that same officer assisted in the search for records. This same officer interviewed witnesses from the scene of 1122 King Road on the 13th of November. This officer did follow up with some of the key witnesses in the case. This officer signed an Ada County lab agreement, and this officer handled and collected evidence. The second officer that I seek the information from did an interview with a key witness that's expected to testify when this case goes to trial. This officer also mentioned a specialty of working with victims and trauma victims. I think those training records are very relevant. The interview of this key witness was one of multiple interviews of this same key witness by various law enforcement officers. There is a lot of information in the various interviews that's going to come into trial. This officer may well be subpoenaed by the defense to come to trial. That person's training records are very relevant. The last officer did multiple interviews, I think a dozen or so, many of them after the arrest of Mr. Koberger. This officer also interviewed key witnesses in the case. This officer attended the autopsy proceedings. This officer followed up on tips. This officer made decisions about the tips that were given to law enforcement. And this officer also collected bits of evidence. Those functions that police officers make daily in their jobs, they make decisions about a case that later comes to court. They've made decisions about the case the state's going to present against Mr. Koberger. They talked to key witnesses. How they do their job, how they were trained to do their job, and what they relied on is incredibly important. When they take the stand, they will say, based on my training and experience, Idaho Criminal Rule 16 talks about witnesses. This is information that the defense needs to conduct its investigation and preparation.
Any response to that?
Well,
I had a look. I thought maybe you wanted to say something else.
not necessarily, other than just to reiterate that this isn't covered by Rule 16, except for if the state were going to rely upon these witnesses and call them at trial, and then at that point, we would furnish all of that. Much of what Ms. Taylor is saying is just pure speculation.
You could say pure speculation, except she just had quite a list of what these particular officers were involved in investigations. So we'll sort that out. Is that it with the motions to compel?
For today.
For today, of course. No motions from the state. All right? Okay.
Well, I'm going to take this under advisement, look at the rules, some case law, and get a written decision on it. So with that, we're adjourned. Thank you all. Have a good rest of your day. All right. Thank you very much. Good to see you. Okay, let's get on the record, please. That's our facing. Technology. Sports. No. It's half there. Just put it flat. There we go. That's good. No? Taylor, what's your preference?
Your Honor, my preference is that it not focus in on the table where my counsel is holding.
Okay, so angle it this way.
They win.
Good.
Good.
All right. Thank you. Okay, we are on the record. This is State of Idaho versus Brian C. Koberger, CR 29222805. Mr. Koberger is here in the courtroom. He is represented by the team of Ann Taylor, Jay Lobson, and Elisa Massett. We also have representing the state, Mr. Thompson, Bill Thompson, Ashley Jennings, Ingrid Beatty, and Jeff Nye. We have several motions set for today. The state's motions are motion for protective order that is related to the investigative genetic genealogy DNA issue, which is related to the Mr. Koberger's motion to compel, seeking those genetic genealogy information and discovery. We also have a motion to reconsider the order staying time for speedy trial. There's also in opposing that, a second motion to stay proceedings regarding alleged irregularities of the grand jury. And from the state, we also have a motion to compel notice of defense of alibi and a motion for scheduling order. So that's what we're going to hear today. I think we're probably going to use most of the morning with the motion for protective order and the third motion to compel. We expect some testimony from Mr. Koberger's team, and that's where we're going to start. So anything preliminary, Mr. Thompson?
No, Your Honor, thank you.
Okay, Ms. Taylor?
Nothing preliminary, Your Honor, we're ready to call it.
Okay, so we'll do that, and then we'll move to argument from both sides. I thought about who should go first in terms of the arguments. Mr. Thompson, go ahead.
No, that's good.
Yeah, I mean, who would first make the argument on the protection order? Would you prefer to do that after you hear the argument from the defense?
it may make more sense, Judge, to do that. I think the record will be better for your honor.
Okay, that's why I suggested that. Thank you.
Yes.
All right, so we'll hear the testimony and then argument from Mr. Koberger's team, and then to the state.
Your Honor, just for the record, Mr. Nye and Ms. Beatty are the ones handling this particular motion. Ms. Beatty has the witnesses, the proposed witnesses, Mr. Koberger and Mr. Nye, of course, briefed the matter and will be prepared for the argument.
Okay, excellent. Thank you. All right, call your first witness.
Your Honor, along those lines, I should inform the court that I'll be handling all of the witnesses that we call today. Ms. Massa will be presenting our argument in support of our motion to compel, and probably the rebuttal to the protection order request by the state as well.
Okay, you all might need to remind me as we go along here.
Sounds fair enough to me.
Okay, Ms. Beatty.
Sir, as a housekeeping matter, I have some objections that I'd like to put on the record.
Okay.
With regard to these witnesses. With regard to Ms. Barlow and Mr. Mercer, the state made its concerns on these two witnesses clear in its reply brief filed on July 14th. But the state believes that calling two attorneys to testify about legal conclusions during a discovery dispute is simply not proper. Both Mr. Mercer and Ms. Barlow consult with defense attorneys on discovery issues, and calling them to testify about legal conclusions in a discovery dispute is tantamount to the state calling prosecutors as staff witnesses to testify about trainings that they've done in a specialized particular area. That's a path I don't think we want to go down, and it's not relevant to the court, and it doesn't fall within 702, which requires specialized knowledge for the fact finder, which is the court in this case. Additionally, Ms. Taylor is an attorney practicing in Idaho who's well regarded and seen as one of the preeminent defense attorneys in the state. There's nothing that these witnesses can tell the court that Ms. Taylor can't simply consult with them about and then argue to the court. So our position is that these witnesses' testimony is duplicative of whatever Ms. Taylor can argue, and it does not fall within the scope of 702. With regard to Gabriela Vargas, the state is objecting to her testimony as well, Your Honor. We received her declaration just yesterday. There was no CV attached. Ms. Vargas is being submitted to this court as an expert witness, and the state has no way of vetting her expertise without a CV. There is no way for us to verify anything in her affidavit. It puts the state in essentially an ambush position where we're being presented with this witness with no way to verify her qualifications. We would ask that this witness be excluded from testifying today as well. And then finally, the state would just make a blanket motion and limit that these witnesses not be allowed to testify about legal decisions or legal arguments. Thank you, Your Honor.
Ms. Taylor.
Yes, thank you, Your Honor. Your Honor, the first two witnesses that the state objects to, Victor Barlow and Steve Mercer, are two people who have been known to the state for quite some time. What they say to you in court now is their objection was made known on July 14th in their reply to, in support of their protective order after we did a response to their motion for protective order and an objection to it, that it's not an objection to them testifying. They spent a lot of pages telling the court why the court should not pay any attention to the declarations that were attached to our third motion to compel. So that's not an objection to them testifying at all. These witnesses have been made known for a long time. They were certainly known last week when we had a planning session and we talked about the number of witnesses that were going to testify. No objection was stated at that time either. Waiting until today, when those witnesses have both traveled and been here and been prepared to testify, that's an ambush, Your Honor. They're here, they're prepared. Their testimonies are relevant to the issues that the court has to decide. They're going to talk to the court about two different things as it relates to our discovery rule and the information that Mr. Koberger is seeking so that we can do our job. Your Honor, you're going to hear from a witness, Leah Larkin, Dr. Leah Larkin as well, and she's going to talk about the process of genetic genealogy. Both Ms. Barlow and Mr. Mercer are attorneys. Both are well-versed in criminal defense. Both are well-versed in DNA and genetic genealogy. The state's position has been that this is not discoverable because we're not going to present it at trial. That's not the end of the story. That's not the discovery rule. And those are the things that Becca Barlow and Steve Mercer will talk about. Becca Barlow has a lot of training in DNA. She does a lot of teaching on DNA as well. It's not a simple little process, and they'll describe what kinds of materials we should have in discovery. Mr. Mercer will talk about what we will do with those kinds of materials and why they're necessary to Mr. Koberger's presentation, the preparation of his case. They'll talk about our constitutional duties to Mr. Koberger. Those are not conclusions. Those are things that have to do with this material, these things that we're seeking the court to order the state to hand over to us, and why they're necessary to the preparation of the case. So for those two witnesses, I can make the argument, but I don't have the expertise in the DNA or the genetic genealogy that the court needs to hear to understand that they fall squarely within our discovery rule. Your Honor, I'll speak about Gabriella Vargas now. Her declaration was disclosed yesterday. Much of that declaration has CD-related items in it. It talks about her background, her training, right in the body of that declaration. That declaration is not as soon as we would have wanted that. Gabriella Vargas met with me a few weeks ago, and for personal reasons that I'm not going to put on the record, she was unable to complete that until a later period of time. So that one is, like, I know that one came in yesterday. She's here, she's prepared to be cross-examined by the state, and certainly there are many other remedies besides just excluding her. The court could allow us to present her testimony, and the state doesn't feel that they've had opportunity to cross-examine her or present a witness in response to her. The court could leave this open and take that up. The court could even order Ms. Vargas to appear by Zoom for further cross-examination. But we should at least let her testimony come out here in court today. She's here, Your Honor.
Thank you, Taylor. Would there be any response?
Your Honor, I think Ms. Taylor has just conceded that these attorney witnesses are going to be testifying about the scope of discovery rules. I don't think that that's appropriate. I think that Ms. Taylor can make those arguments to the court that having fact witnesses interpret the law is not appropriate in a discovery dispute. As to Ms. Vargas, our understanding was that there were 3 witnesses testifying today, and that was our understanding up until yesterday when we got into town. So we would ask that Ms. Vargas be excluded. And I would note that we made our objections to these witnesses clear when we asked the court to disregard the contents of their declarations in Mr. Nye's reply brief. Certainly, we're going to put that same objection on the record. Thank you, Your Honor.
Thank you. Well, a couple of things. I'm concerned about these opinions about sort of constitutional law or the procedures of discovery. I think that's fully capable for all of the counsel here and for me. Those are going to be my decisions. However, in reading through, and I have read through all of the declarations, pointing on specifically genetic genealogy and their experience with that within the law, I think does have some relevance, potentially. And I think that it would go to the weight of the consideration. The other thing that I am concerned about is this is a death penalty case. And if I deny particular presentations that one or the other side believe have some bearing on the case, it's probably more wise for me to allow it, even if it might be on the edge, than not allowing that record. It's especially important in a case like this to have a record for appeal. So I'm not saying one way or the other how this might fall, but I think it's important to preserve the record. Now, however, I don't want to get into arguments about the law or what that exactly means. I think I have a pretty good understanding of what the issues are about the genetic genealogy issues and why the state wants to get more information about that. I also understand why the state believes that it has nothing to do with the case. That's what I'm going to hear from today, and I think it's important to have both sides weigh in on this. Now, with regard to Ms. Vargas, she is here. I don't know where she came from, how far away. I'm inclined to just allow the state to come back and address that if we need to do that. And also file another brief objection, and I may decide to reject that. So that's where I landed on all of that. So I'm going to deny the objections, overrule them, and we shall proceed with hearing the testimony. Now, if you get too far into this is what the law requires, maybe you're going to have objections. So okay?
Thank you.
So call your first witness.
Your Honor, if I may, one point of clarification. It occurred to me while listening to the court talking about genetic genealogy and really that being a focus. There are a couple of other areas contained in the motion to compel that have to do with the other DNA that the state doesn't have complete discoveries to us that are included in that third motion to compel that are up for today. The big focus has been the genetic genealogy piece, but I wanted to make sure that that was still in the scope of the court.
Well, my understanding was that the state did provide all the information about the laboratory, we'll say the laboratory DNA that was, that analysis was not related to the genealogy DNA. Am I mistaken about that? What are you saying that they didn't provide to you?
Your Honor, in our third motion to compel, we had a section called standard lab discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheep, the DNA found on the night sheep, but not the other 3 unidentified male DNA samples, 2 from within the house, 1 from outside of it.
All right. So if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kober.
Correct.
Okay, any response?
Your Honor, we didn't realize this was going to be an issue today. We had given the defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist. We've provided everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel of the crime scene itself. We'll be receiving today. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. And they're hoping that there's something else there. It's not there.
Ms. Taylor?
Well, Your Honor, it's part of our third motion to compel. It's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion.
I understand, your responsibility is to turn over every rock. But you can't get things that don't exist as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. And so Mr. Thompson is saying that there's one more lab report that is coming your way today, I heard him say.
Maybe not today. We were waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood that. So it's coming soon. It has to come soon because we're 6 weeks away from the trial. So we're going to be very rushed about a lot of things, but I'm going to talk about that a little more later too. So what about the other claim, Mr. Thompson? Do you want to address that? The other mistakes?
Corrective action log, unexpected result log. We have that in part, but not the full scope.
I don't know what exists that we haven't received. We provided all the requests to the lab, and they've assured us that they have provided us with everything that they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish in court today. But I'm kind of sitting here saying, Judge has given me everything we know to exist.
Well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now at an appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case. That's how I'm.
Ms. James is making a note right now. We'll send the inquiry out later today.
Okay.
Thank you, sir.
Your Honor, just for point of clarification, we also ask for all emails, text messages, electronic messages, or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete file.
Okay, Mr. Thompson.
We have told them, we have given them everything that we know to exist. We've asked the lab provided it to us, we sent it to them. At this point, all I'm hearing is speculation, is they think maybe, or they wish something else was there. But as far as we know, it doesn't exist. I don't know what else we can say. You can't respond to something that isn't real. Sorry, Judge.
I mean, we're just sorting it out.
Yes, sir.
Making sure that everything that there is shared. Except the ones that you don't want to.
Absolutely, yes, sir.
And that's one of the reasons we're here.
We'll make an additional inquiry to the lab to see if there's anything else in the form of emails that they haven't already provided to us.
I would add, I mean, there are times, okay, in the world of the law, that sometimes people forget to do things, or sometimes things fall through the cracks. And so it's always healthy to make sure that it is done thoroughly.
Absolutely. Thank you, Judge.
Thank you.
You're now ready to call Steve Mercer.
Okay. Just one moment. Are your experts in the courtroom right now?
Yeah.
Do they need to be in the courtroom?
Your Honor, I'd ask that they be allowed to remain in the courtroom, seated where they are, so they're just kind of alone.
Right. Any objection to that? I don't know who to point to here.
Sure, we'd ask that the witnesses be excluded.
I'm going to exclude your witnesses, so they're not hearing what the other witnesses are testifying by. And that'll be, I think, a cleaner, more accurate response. So then I don't want to have them reacting to the other testimony. We'll hear each testimony, of each witness's testimony be independent. Okay, so could you please have your other experts excluded from the court?
Where would the court like them to go? This is a media intensive environment, and I don't want them to be bothered by media walk away from
The law library.
May I escort them there?
Sure. Thank you. Sorry, Mr. Mercer. No, no, no.
Thank you, Your Honor.
Okay. Thank you, Ms. Taylor. Okay, Ms. Mercer, hang on up. Please raise your right hand. Hey, yeah, it's.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do. Thank you, Mr. Mercer. Go ahead, get some water there. I'll take care of that. And once you're seated, you please state your name and spell your last.
Yes, my name is Stephen with a PH Mercer, M-E-R-C-E-R.
All right, thank you, sir. Okay, Ms. Taylor.
Good morning, Mr. Mercer.
Good morning.
What city and state are you from?
Rockville, Maryland.
What do you do for work?
I am a licensed attorney in Maryland and the District of Columbia in the field of criminal defense with an area of specialization in DNA and forensic litigation.
How long have you been an attorney?
I was licensed in the state of Maryland in 1995 and in the District of Columbia in 1997. I'm also a member of several federal bars, including the Supreme Court, where I appeared as co-counsel in Maryland v. King, a DNA database case from 2013, as well as the Fourth Circuit, the DC Circuit, and a number of federal district courts.
I want to back up a little bit and have you tell me about your educational background.
So I have a undergraduate degree, bachelor's degree in English from Syracuse University, 1984. Juris Doctor JD from the District of Columbia School of Law from 1994.
And you mentioned you have a specialty in DNA. Where does that come from?
So my experience with DNA began with the first constitutional challenge to Maryland's DNA database statute, and that started in 2002 in the case of State v. Raines, where it raised a Fourth Amendment challenge to the compelled collection of DNA from convicted offenders, prevailed on that case in the trial court. It was appealed to the Court of Appeals, which is now called the Maryland Supreme Court. The Maryland Supreme Court, in a sharply divided 4-3 decision, reversed, sent it back for trial, tried the case, and that was really the beginning of my experience with forensic DNA litigation. And then from that point, I continued in that field, attended training with the District of Columbia Public Defender Service. I began to collaborate with the Innocence Project in the Forensics Division at the Maryland Office of the Public Defender, doing indigent defense work and innocence work, and began to work closely with DNA scientists who actually did the wet chemistry work had numerous opportunities to tour law enforcement labs, including the NIST lab, as well as Montgomery County's lab, Bodie Technology, the FBI lab, as well. And so I continued working in the field, providing both direct representation in DNA cases as well as consultation through my private practice. And then in 2010, the public defender recruited me to head up the forensics division at Maryland's Office of the Public Defender, which is a statewide public defender system. And then there, I really dived much deeper into the field of DNA forensic litigation at that time. And if there's some questions, I can explain that further.
I may ask you some others about that in just a moment. Would you tell me about any publications, any articles that you
Yes, so I published an article, co-authored an article in Maryland's DNA Databank back in the early 2000s following the State v. Raines decision. I also published an article in the NYU's Law Review about shadow DNA databanks with a co-author, Jessica Grable, and those are the principal articles with respect to forensic DNA.
And I think you mentioned a couple of professional organizations that you belong to. Are there others?
Yes, so I'm a member of the jurisprudential section of the American Academy of Forensic Sciences, and I've given presentations there. For example, in 2018, I gave a presentation on proposed regulation of the field of forensic genealogy. And then I'm also a member of the National Criminal Defense Attorneys Association and a number of local bar associations in Maryland, as well as the State Bar Association.
You mentioned forensic genetic genealogy just now. Can you tell me your background related to that?
So following really the advent of forensic genealogy in 2018, that is when I had the opportunity to litigate cases, criminal cases involving that technique, the testing and the investigation related to the testing, and to receive discovery of the testing, and the interpretation of the test results that were obtained through searching of genetic databanks.
You are here on Brian Koberger's case. How did you become involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to discuss Idaho's discovery rules or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a minimum practice standard would be for a reasonably competent trial attorney who must comply with their duty to investigate a case on behalf of their client.
And is that because of what you get when you get genetic genealogy materials?
Well, yes. I mean, forensic evidence is often central in a case, and DNA evidence in particular. And so when there's an item, for example, here of an environmental sample of trace DNA evidence that, as I understand it from reviewing the pleadings, was twice tested, first for an STR profile, and then later for a genomic profile. The question becomes, what is the minimum practice standard for an attorney to be effective in your representation of a client given that type of evidence?
When you're talking about two samples happening, or two tests happening, why should an attorney know about that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of data banks that violated the terms and conditions of those data banks? Was there surreptitious DNA collection from individuals, targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here to understand, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint, and it says nothing about who the person is. But now with forensic genealogy, we're talking about genomic profiles, potentially whole genomic profiles, or at the very least a SNP profile, single nucleotide polymorphism profile, single nucleotide polymorphism. An SNP profile that contains a vast amount of information that is very, very private. And so this is a real game changer in the privacy interests that are at stake, and that the attorney needs to understand in investigating the case to assess and to evaluate that suppression issue, that Fourth Amendment issue. So that's one issue pre-trial. There's also concerns about reliability. And by reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because as I understand it from the pleadings, there were multiple tests on the same evidence, environmental sample of trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, in other words, potentially the entire human genome that is typed from this environmental sample of trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall. And so what I would be investigating with a qualified expert is, number one, and I don't know from the pleadings if there's a whole genome profile that's been developed for the forensic genealogy, but if there is, that should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential for an undetected low-level mixture? Those types of questions that are potentially available to inquire and ask about, where you have multiple tests of the same piece of evidence and it's an environmental sample of trace DNA. Now, if it's just an SNP profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information, SNP markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts that they retain. But they can't even decide what experts to retain without having the discovery. And that's the minimum practice standard. And that's a point that I've made in testimony before courts where I've been accepted as an expert in Maryland, DC, and Virginia, that the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, and particularly where we're talking about an environmental sample of trace DNA, it's absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, and what have you. Now, also with regard to the respect of forensic genealogy, it's important not to separate this out into all these different components. It is, you have the SNP testing, and then you also have the development of these family trees and database searching. This is all part of the same testing and experiment. They go really hand in hand, and you can't unravel them. They really have to be considered together as a single core of different strands of the testing and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues, and the government is introducing the STR profile. They have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to. And so an area to look into and to inquire about are the limits of the statistical tool that the government is using, or the state is using, which is based on the premise that sort of what's called the random person not excluded. And that's answering the question of the rarity of a profile in a population of unrelated people. But the key point there is unrelated. So we know there's no universe where a STR profile has no relatives. And in fact, in a case involving forensic genealogy, the way that the defendant is identified is by searching a pool of related people. And so we need to be able to investigate and evaluate the rarity of a profile within a related population. And that's a different question than what the government answers with its random person not excluded statistic that is typically used. And so, again, without the discovery of the forensic genealogy, both the testing as well as the experiments that are done with the test results, i.e. the database searches, as well as the family tree build out, the attorney can't investigate that. In that situation, by not investigating it, is not complying with their duty to investigate that is required, especially in the capital case.
I've heard you say that when you have a sample, in this case would be an example obtained from a knife, that was STR testing done, and then when you go, when you have genetic genealogy testing, you end up with whole genome testing or an SNP profile. Did I understand that?
Yes, and it's unclear to me at this point what type of genomic profile was developed, whether it was a whole genome sequence or whether it was an SNP profile, which contains about 700,000 locations of very personal, private information.
I think I heard you say that no matter which one of those was done for genetic genealogy, that you need to look at those to test the reliability of the STR profile. Did I hear that right?
Yes, so this is, as an attorney and not a scientist, but as an attorney who has a duty to investigate, this now is an area where the attorney will look to retain a qualified expert who can evaluate and assess the linkages between the SNP profile or whole genomic profile and an STR profile. To be sure, an SNP profile or forensic genomic profile can't be searched in CODIS. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile, you would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile to then evaluate the reliability of the STR profile, the potential for any mixture, the potential for any artifacts in the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers would be.
Can I clarify something? Sure. So what you're saying is that you need to look at the qualified scientists who have to look at the SNP profile to compare it to the SPP profile for reliability of the SPP profile.
The STR profile.
STR.
Yes, so there could be clues, absolutely, that could be discerned from an analysis of the SNP or whole genomic profile. Because again, we're talking about two different tests of the same piece of evidence. And there have been, in peer-reviewed publication, I mean, one that comes to mind is Jae-Wah Kim, who published in the journal Cell about how an SNP profile can be linked to an STR profile. And that's by zeroing in on sort of the neighboring regions and examining those. So yeah, I'm not a biologist or a scientist, but I'm an attorney, who has a duty to investigate, and to investigate requires hiring experts that hasn't been released yet. And so that's why the minimum practice standard is to get that discovery so that the attorney can then assess that discovery and then retain a qualified scientist.
Okay, so that having that profile on the SNP can verify the legitimacy of the STR.
Right, so that's my hypothesis, that's what I go to the expert to inquire about, because again, this is a very much an emerging area of forensic science and litigation.
Sure.
And
Evolving.
yes,
I'm
evolving.
going to object again. I don't believe that this witness is qualified to opine on what's needed in these scientific processes. He just indicated that it was his personal hypothesis. I would remove my objection on it.
Well, I'm gonna overrule that because I asked the questions. I apologize. Go ahead, ask your next question.
When I'm talking about either the whole genome or the SNP profile, am I looking for just like a sheet of paper that has a bunch of numbers on it, or is there a packet of information that I need to go to my expert?
No, you need the raw data of the profile along with, it's similar to the sort of data that you obtain for the SDR test. You get the raw data of the profile, you get the laboratory protocols, you get all the bench notes, you know, how the profile was generated, but also you should get the discovery about how the profile was then searched in different databases and family trees constructed.
That was going to be my next question. I heard you say that we can't look at this whole genome sequencing or the SNP in one category and then look at the building the tree to identify from the genetic genealogy piece, the genealogist piece, in its own separate area. They're not two separate lanes that they combine.
Yes, they go hand in hand. You do one or the other. I mean, they go together.
Why?
I'm sorry?
Can you tell me why? Can you explain why you say they go together, why you code?
Well, the SNP profile is what is searched in the ancestry database to then identify, you know, potential relatives, and then family trees are built out. That's the object of the SNP testing. What's important to know from a defense perspective in terms of trial work and potential areas of cross-examination, the government is going to be introducing a statistic that is premised on the assumption of an unrelated universe of people. So what's the chance of finding a profile in a population where there's no relatedness between that profile and anyone in that universe? And so, as you know from talking about this whole concept of forensic genealogy, people who are related have similar DNA. And so the statistics change when you are talking about the chance of finding a profile within a related pool or related universe of individuals. And that's a legitimate area of inquiry on cross-examination for the defense to demonstrate the limitations of the statistical questions that the state is presenting to its expert witness. And to do that, you need to know, for example, who the population of related people are, who is often, from my work on the forensic genealogy, what I've seen is that when a match is found, when the STR match is found, then all building out, all further testing stops on the forensic genealogy side. And so it's important to know who hasn't been tested on the related person side in terms of developing cross-examination about the limitations of the statistical tool that the state uses in its case to demonstrate the rarity of the match that they're presenting.
Have you received genetic genealogy materials in your case?
Yes, so which wasn't surprising to me, because even though typically the government doesn't seek to introduce the forensic genealogy, in its case, it nevertheless is evidence that is a scientific test of material in the case. And so the discovery rules typically call, for example, in Maryland, in the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either a materiality showing or that the item is introduced into evidence. And so even where there's a limitation on the item being introduced into evidence, that really goes to the item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
Isn't just 1 minute? Thank you. Mr. Mercer, I don't have any other questions. I'm going to hang on just a minute and trust you.
Thank you.
Katie?
Your Honor, I have no questions for this witness. Mr. and I will be making multiple arguments.
Okay, thank you. Okay, may this witness be excused? Any objection?
No objection.
Okay, you're excused. You can now stay in the court if you like.
Thank you very much, John.
Appreciate you traveling. Thank you. Been about an hour. Maybe I need to give the court reporter a break. How about just a short one, 5 minutes, 10 minutes, maybe 10 minutes. Okay.
Remember, that will give me time to have our next witness set up.
Okay, great. Okay, 10 minutes, and we are off the record.
Forensic kit for forensic purposes, you can upload that to 2 main databases. One of them is called Family Tree DNA, which in the trade we generally just call FTDNA, and the other one is SNATCH. And there are a couple of smaller databases, but they're really tiny.
You can go to Ancestry.
No. Ancestry will not let you upload a file into the database, nor will one bring. There's no process to do it. The only way to get into those 2 databases is by spinning it.
All right, on this slide, does this represent most of these companies that do the genetic analysis?
Those are all of the main companies. There are a few smaller ones, but they're really quite tiny, and often for those we don't even have decent estimates of how large they are.
By large, do you mean the number of people that have uploaded a profile or spin their tubes, the ones created?
Yes.
There. And I think you let us know that law enforcement uses and can only use GEDmatch and Family Tree DNA.
Per the terms of service of the companies, they are only allowed to use Family Tree DNA and GEDmatch, and there are 2 smaller dedicated databases. One of them is called DNA Justice, which has, as of yesterday, about 500 people in it. And the other one is DNA Solved, which is owned by Optum, and I have no idea how many people are in it.
Those 2 that you just talked about, can anybody use those, or are those only law enforcement can use those?
DNA Solves and Optum?
Yes.
Yes, those are only for law enforcement. A regular genealogist wouldn't have access to any output from those. You can voluntarily contribute your DNA, but then you can't use it for your own genealogy.
And GEDmatch and family tree DNA, are those law enforcement only, or are those usable by others?
Those are usable by regular genealogists, and both of them existed long before the field of forensic genealogy did.
But they also allow?
They both allow law enforcement to upload the kits, the DNA kits, into their databases.
MyHeritage, I don't think we've talked a ton about that. I understand Ancestry and 23andMe, you have to give your own sample, they do their own thing. But MyHeritage, how do you have to do this fitness proof for that?
No, so MyHeritage sells DNA tests, as does Family Tree DNA. So you can send a kit in. Those are cheek swabs, they're not stick. That's technical. But for both MyHeritage and Family Tree DNA, you could test directly with them, but you could also take your data file from one of the other companies and just upload the file. And it's just a text file that has thousands and thousands of lines of DNA data.
So as a genetic genealogist, you are working with somebody and you can take their profile that was made at 23andMe and put it in MyHeritage and Family Tree DNA.
Yes.
And you also put it in GEDmatch.
Yes.
And law enforcement can only search Family Tree DNA and GEDmatch. Can they search your person?
If there's a DNA match to my person, they will see that match.
Okay. Does your person have to agree, law enforcement, to let that happen?
If we're talking about my adoptee, so it's complicated because the rules have changed continually over the past few years. As it currently stands at GEDmatch, if we were to take a brand new kit, a brand new adoptee client, and upload their data to GEDmatch, we would have to consent. The client would have to either consent or decline to consent to participate in law enforcement matching.
If they decline to participate and law enforcement searches GEDmatch, then they should not see your clients. Is that
They
right?
should not see my clients.
Okay. Same with Family Tree DNA?
Family Tree DNA, the system is kind of the inverse. If you add a kit to Family Tree DNA, they automatically opt you in. There is a way to opt yourself out, but you kind of have to know where to find it. It's not obvious.
Again, a person can keep their information private, so it doesn't wind up in law enforcement searches.
They yes.
Family Tree DNA. And MyHeritage is different, law enforcement shouldn't upload.
MyHeritage explicitly prohibits it.
Did I just ask you all questions that related to the arrows?
No. So the database, the total database at Family Tree DNA and the total database at GEDmatch are both larger than the number of people who opted in. So not everyone at Family Tree DNA has opted into law enforcement matching. Not everyone at GEDmatch has opted into law enforcement matching. And so the arrows are the gray bars are showing my estimates, and these are my personal estimates for the number of people in each of those databases who are officially accessible to law enforcement for matching.
And that's because those companies have two categories of
Yes.
I think we're now to the last section where we're going to talk about the work products of genetic genealogy. What does that topic mean?
So these are if I have an adopted client, this is what I would give the client at the end of our agreement. These are the products that I would give them, and in basically everybody who's doing forensic genetic genealogy that I know of, except possibly the FBI, originally trained as a genetic genealogist. So this is what we are all used to giving to our clients.
What are we seeing on this first slide that you did to your clients?
Okay, so those are two of the match lists. The one on the left is what a typical match list looks like at GEDmatch. The one on the right is what a typical match list looks like at Family Tree DNA. For my plans, I will actually screenshot the matches and put that in the appendix to my report. I also copy all of the matches into another program because sometimes people will, they'll be in the match list of my adoptee, and then they'll disappear. And so I like to have a record that, hey, when I uploaded this kit, I had these matches there. So even if they decide to delete their kit later, I still have a record that they shared so and so much DNA with my client.
This looks like a family tree.
It does look like a family tree, and it's anonymized. There are no real.
Dr. Larkin, what are we seeing on this family tree?
So this is the family tree that I would have built for my client. And this would have attached to it documentation, so birth and death records. It would have census records if I was able to find the family in the census, immigration records, any sort of documentation that I might find. I often will link obituaries if I find them, if I find family photos. A lot of times you might find articles in the newspaper, and I will link everything that I find to this family tree that I then give the client.
Does that help verify for your client that the results you gave them were accurate?
Yes, it helps verify that all of the relationships that I'm reporting to them are documented and yeah.
And it looks like you give them a copy of the descendant diagram.
I do.
And you give them a copy of what are the odds?
I do.
And a written report.
I do. If the client requests it, I will write a report for them.
Other than those things that you give your clients, what would be available on the forensic side of the genetic genealogy?
Right, so they should have the original DNA data file, whether it was a microarray or the next generation sequencing. I don't need to give that to my client because they had that with them. There are some complications when you're dealing with forensic DNA because I didn't have a person spit a whole bunch of DNA into a tube. Sometimes you might have a mixture where more than one person is represented in the sample. So that needs to be analyzed, and there presumably would be documentation associated with that analysis, which is called deconvolution, deconvolution. If there was not, if there was non-human DNA contamination mixed in with the sample, sometimes, and not always, sometimes they will do what is called enrichment, where they're trying to increase the proportion of DNA that is human in that sample. If that process was done at the lab, there should be a record of it. The bioinformatics that we talked about, so imputing any missing data and then stripping out all of the non-genealogical DNA points, all of those, there should be records of.
Oh, I think you have logins or kit numbers.
Right. So when you have once you've gone through all these steps, you've done what we call the wet lab work, where you're actually working with the samples, and then you've done the computer analyses. You end up with the output file that mimics. It's like a fake microarray file, right? So it mimics the data that we would have gotten from a genealogy company. GEDmatch and Family Tree DNA both charge law enforcement to use their database, and so there should be some sort of contractual agreement or receipts that you paid the company for the upload. And then there are logins, because for you to be able to see the matches, you have to log into that account. You have to have access. You have at Family Tree DNA, you have to log into that specific account. At GEDmatch, I believe you can give access to a few different researchers, but they have to know what's called a kit number, which is the unique identifying number for that kit.
When you said a fake microarray, it reminded me that when we talked about microarrays, you told us that those contain a ton of like personal medical information.
Yes.
This also has all that personal
Yes.
medical? And do you, because there's so many more, I guess, people or kids or profiles in that area, is that a place that somebody that can find a match might want to go?
Yes.
Dr. Larkin, thank you. I don't have any other questions, but don't leave quite yet. I'll pass it to Mike.
Thank you. Any cross-examination?
Should have referred back on her.
Okay, thank you. All right, may this witness be excused?
Yes.
Okay, so you're excused. You can stay here if you like, or you can get on with your life. Thank you. It's very educational. Well, it's 1 o'clock. I think it's a good time to break, maybe until 2. How much longer do you think?
Your Honor, I have 2 additional witnesses. I believe Dr. Larkin was going to be by far the longest witness. I think the next 2 will be, I would hope, not more than an hour combining. Maybe not even take that long. And then argument, Your Honor, and know we're going to take up the state's second order request at the same time.
Sure. Okay, great. We'll reconvene at 2 o'clock. Thank you.
I'm going to ask you a question and then come back to it in a minute. What kind of work do you currently do?
I am an investigative genetic genealogist and also a woodworker.
Woodworking sounds really interesting. I think we're going to focus on your investigative genealogy today. But before we talk about your work history, I want to know a little bit more about your educational background. After high school, did you have more formal education?
I did. I went on to the College of San Mateo and received a degree and certificate in administration of justice and full certification. And then I went on to San Jose State University and studied criminology and with a minor in sociology.
Did you graduate?
I did.
And was that with a bachelor's degree?
It was.
What year was that?
What year were we in? I want to say 2010, maybe? Agree or not? I don't remember.
It's been a few years since you graduated?
It's been quite a few years.
Right. Did you take any courses in forensic genetics?
At that time, this did not even exist. And the courses only have started to recently come out. There is no current standard of certification for the work of an investigative genetic genealogy.
Is that newer than your college education degree?
Absolutely. This is a technique that only has come to light in the last 5 years.
And now we're talking about the forensic investigative genetic genealogy.
Yes.
How did you get interested in that?
I really had no knowledge of it when I got involved. I had some health issues that I was going through and needed genetic testing. Unfortunately, my insurance wouldn't cover it, so I took direct-to-consumer DNA test and used the results to upload to a medical site. In the process of that, I found out that my father was not my father, and I then went on a mission to figure out how to identify who my biological father was.
Personally involved in the justice is very much self-taught.
100% self-taught. And this was a time in my life where I was going through cancer treatment. I had a very short prognosis of lifespan left and became incredibly depressed. And so once I identified my biological father, I then wanted to give back. And so I started a free online Facebook group for people who had gotten the same results or were adopted or donor conceived, and I started finding their relatives for them.
That turned into you attending the trainings for genetic genealogy?
So at the time, I did not. So in 2018, in the spring, is when I started doing just genetic genealogy, which is the same concept essentially, but you're just doing it with adoptees, donor conceived and unknown parentage cases. I did a lot of online readings and reading scholarly articles, watching tutorials, just learning about the technique itself. I didn't have any involvement in investigative genetic genealogy until August 2019, when I was asked to join one of the companies that provides that service.
When you joined that company, did they train you in those methods?
No, they actually presume that you have to know what you're doing in order to be a part of the team, and so the presumption is made that you already have enough experience. I continued my own education and training by attending conferences, doing workshops, following other pioneers in the field that had successful case rates, and continued to just educate myself through what I could find on the internet, because at that time, certification programs, accreditation, any sort of courses, they didn't exist. Those are very, very recent things that have come out.
You mentioned that there were groups of people that you learned from and worked with. Did you check your work or have them check your work as you learned?
Oh, absolutely. The first company, so I've worked for two well-known companies in this industry, and then I have created since my own company. One of the first company, you worked individually on cases, but it's a collaboration amongst the team, and so you keep each other up to date on what's going on. You ask for advice, guidance, help. The second company that I worked for was more of a team structured way of working cases, and that was at the point when I began actually training all incoming volunteers that wanted to get to learn how to work these cases.
That first company you worked for, what was that called?
Identifinders International.
And how many years did you work for Identifinders?
Just over 2.5 years.
And that's where you did investigative genetic genealogy and other teenage check your work?
Yes, with Identifinders, I only did suspect cases, so only murder and rape, violent crime cases. They did not do DOE cases at the time that I was working with them.
So you're talking about those kind of cases that you did, those were for law enforcement, you were identifying somebody that was unknown.
Yes.
Okay, and you worked with checks there while you did that for 2.5 years?
Yes.
Okay. The next place you worked, what was that?
The DNA DOE project.
What do you mean by that? You mentioned that in your last.
DOE is an unidentified remains. The DNA DOE project specifically takes on adult DOE cases, not baby cases. So I work those cases on my own with my company, but it's identifying not suspects, only unidentified remains.
And you were not law enforcement there, you were not doing anything for law enforcement there, so it's a little bit different, do I understand that right?
So for both companies, we were working on behalf of law enforcement. We would contract these cases with law enforcement, but law enforcement was not in fact working the case. The genealogists were working the cases.
Okay. For law enforcement to get it answered?
Yes.
All right, and so how long did you work at that location?
I was with the DNA DOE project for about 2 years.
And is that where you did some teaching and training about genetic genealogy?
Yes.
From there, where did your career take you now?
Well, I ended up opening my own company, but the DNA DOE project offered me the opportunity to be an intake specialist. So my primary role was when somebody was interested in doing this type of work and wanted to learn the technique, we would bring them on board, and I was the one who would teach them the process. So all new volunteers were on a specific case that was run by me, and I would not only train them, but also check their work, make sure that they were documenting things properly and that the documents matched with the proper person that they had put in the tree. I also, the University of New Haven had also started a forensic investigative genetic genealogy course that you could take that had a practicum at the end of it. The DNA DOE project was the first organization that took on a cohort of students. The first year of this course that was offered, it wasn't fine-tuned. So the students that I took on for the internship, there were 6 students in total, they really had very limited knowledge of the technique, of the meaning of anything really. And so I would spend hours training them, and at the end of 7 weeks, I led them to a solve of a case.
You were trusted with me?
Yes, I was.
Do you know roughly how many law enforcement forensic investigative genetic genealogy cases you worked?
I have worked just for law enforcement cases probably around 25 to 30.
And the DOE project, how many of those kind of cases?
So that would include all cases.
The 25 includes the DOE cases?
Yeah, it's about 25 to 30 would encompass any case that I have worked that is law enforcement case, not including the cases that were unknown parentage cases.
And of the other kinds of genetic genealogy, how many times have you worked with case in genetic genealogy other than that?
How many cases? Minimum 25. I still have people every day who, it depends. Some people just don't know what any of this means. And so it's as simple as just looking at their matches and explaining it to them, and they do it on their own. But actually working cases, probably another 25 to 30 that are just unknown parentage cases.
And have you testified before in court?
I have not.
Let's talk about what brings you here. How did you get involved in our case with pregnancy?
I was contacted by defense. well, I take that back. I was contacted by somebody in this field, I don't know if I can say who it was or if it's relevant, asking if I would be willing to talk to the defense. And I agreed, and I had that, it was a Zoom call in which I was asked basically just to explain the process in which I go through from start to finish on a case. So what is, from when law enforcement contacts me to when I provide the investigative lead back to law enforcement, what is the process? And that was the extent of my involvement at the time.
Ms. Vargas, what I want to do is I want to briefly run through that. What do you do when law enforcement calls you and you get? What's your first step?
So it's a complex, it's very complex. Essentially, law enforcement will contact me and say they have a case that they are unable to solve and they would like to, they like my services. I first evaluate what type of case is it, and are there any, what is the DNA that is involved? Do we have to extract the DNA? Have you already extracted the DNA? So there's a lot of preliminary questions. Once we establish that and they agree to take, have me take on the case, I have them set up to ship the sample, whether it be something that needs to be extracted to the lab that does that, or DNA that's already been extracted that needs to be sequenced. The law enforcement agency will then send that to a third-party forensic lab. At that point, when the lab receives the sample, I essentially take over the case until I provide the genetic lead back to, or the investigative lead back to the agency. In the meantime, I will stay in contact with usually the detective and provide updates on, did it pass quality check in the lab? It's being sequenced now. The data file has been complete. It's gone through bioinformatics. I've uploaded it, to GEDmatch. Do you want to upload to FTDNA, Family Tree DNA, because there's an additional charge for that? And so I keep them kind of abreast as to what's going on, but essentially the case is it's mine. It's in my control until I am done.
And do you, during those communications with law enforcement, do you take their direction, and if they say stop working, you stop working?
Absolutely. The case belongs to them. It is not my case. It is not my data. I am providing service for them. The only request that I have is they not have another company work the case at the same time, because it's just a lot of work that you go through. But I am at their direction. Yeah, I don't.
So it's not as easy as just getting a profile and sticking it in your computer and having it.
Oh, absolutely not. I've had cases that have taken me 14 months to solve.
Why, you mentioned you use GEDmatch for Family Tree DNA, but there's an extra fee involved in that. Can you explain that a little more?
So there's only, there's many direct-to-consumer databases, Ancestry, 23andMe, MyHeritage, Family Tree DNA, all of which you can order from the company a DNA test, spit in the tube, and send it off back to the company. Ancestry and 23andMe allow you to download your data and upload free to these other sites as a normal consumer. Law enforcement cases, however, are only permitted to be uploaded into Family Tree DNA and to GEDmatch for a fee. GEDmatch, however, is not a direct-to-consumer testing site. It is only a database where people take their test results from the company in which they tested and upload this site to the site to get more matches, essentially, or higher, closer relatives, higher matches.
Does law enforcement have access to all of GEDmatch data?
If properly uploaded, there's a fee that you must pay. You must upload through a separate database than the one in which consumers upload through. You must pay the fee, and you, depending on the case, may be limited on the matches that you are able to see.
Why is that?
The terms of service have changed several times since the Golden State Killer case came out, and which investigative genetic genealogy became very popular. It used to have everyone opted in, then GEDmatch opted everybody out, and you had to choose to opt into law enforcement matching as a consumer. Then it decided to automatically opt DOE cases in. So to break that down, if you were to take a DNA test of ancestry and want to upload to GEDmatch, when you input that file, it's going to ask you, do you consent to law enforcement matching? And if you hit no, and I am working violent crime non-DOE case, I should not be able to see that you are a match to my unknown DNA contributor.
You said should not.
Should not.
Does it happen anyway?
It does. It has.
And is that because there's a problem with GEDmatch? It's just if you upload it and all of a sudden these things that shouldn't happen did?
There there are a lot of tools that are available in GEDmatch. These tools allow you to make comparisons of two or more people and how they relate to each other and share DNA. One of these tools allows you to compare many matches, not only against your DNA profile that you're working, but also against all of their matches to see if their matches match each other. When you utilize this tool, there is a feature that you can edit the list of kits that are originally selected.
What does that mean, edit the list of kits?
So when you upload your profile, it takes about 24, 48, 72 hours max to batch and tokenize in the system. It then produces a list of matches, okay? And these matches are biological relatives to the unknown DNA contributor. We don't know right away what relationship they are, but they are all biological relatives, okay? One of the tools is called the matrix tool. And what the matrix does is it compares the match, the DNA profile against a specified number of the profile's matches. So for example, if I run the profile's kit number, they're all given a kit number. If I run the profile's kit number and I compare it to 100 of the profile's top matches, it will in turn compare the profile to all of the matches and all of the matches to everyone on that list of 100 people. Okay?
Okay, I see what you're saying. Let me make sure. So you have one person, you get a list of their matches, but this tool also gives you a list of those matches.
So it's a multi-step process. So initially, if I am putting my subject's DNA in the system, I don't know who it belongs to, I put their kit number in. You get a kit number after you upload the data, okay? I put the kit number in, I run a tool called one-to-many, and it's gonna show the top 500 matches that this subject has. I then would go to utilize the manipulation tool, the loophole. You would then go click the top match and run their matches. So the top match of your subject's top match, you would run their matches, okay? Once you run their matches, there is a tool that allows you to edit that list of matches. So we're looking at the matches of the subject's top relative, not the subject's matches, right? When you edit the kit list, if you put the subject's kit number into this tool that you're going to now analyze, these matches, it tricks the system and allows you to see matches that you wouldn't have seen when you ran your initial match list.
And those can include people that did not agree with law enforcement to see their DNA.
Those matches that are revealed are only matches that have been opted out.
And that is only the ones that are supposed to see.
They're only the ones. If you see that the subject matches one of these people, because again, you're not looking at your subject's matches, you're looking at that person's top cousin, let's say, that top cousin's matches, right? When you put your subject's kit number in there, you're gonna see now his kit, her kit, compared against the matches of their top match. When you find, you then scroll down and you look, oh, here's the match for 100 centimorgans. You go back to your screen where you have your list of your subject matches and you say, I don't have a match with 100 centimorgans. That proves that that person has opted out of law enforcement matching, but I'm still able to see them.
And so that's a way to use the tool to get past what law enforcement is supposed to do.
I struggle with this. I'm sorry. It is a tool that is provided in the database that essentially allows you to see things that you're not supposed to see. And as a result of seeing those things, you're then using that match to find to identify your subject. So you're violating the terms of service by seeing these matches.
This is in Gen.
This is in Gen match.
How about family tree DNA? That's the other law enforcement database.
There's two things that I'm aware of in family tree DNA. One is not paying to upload, So there's very strict parameters when it comes to law enforcement kits. One of the parameters is if you as a consumer are a match to a law enforcement kit, you cannot see that kit as a regular consumer. So law enforcement kits can see everybody in the database that have opted in. Now, Family Tree also has an opt-in out feature that is not the same as GEDmatch. You have to go into the settings and find it and toggle whether or not you choose to opt in or out. Many people are unaware of this. Another instance is uploading the data as if you were a consumer. You bypass the fees that you're supposed to pay to Family Tree DNA for a law enforcement kit, whereas a consumer it's free. And you also get full access to the database, including matches that have opted out.
Does this happen?
Yes.
If I'm an attorney and I have a case where genetic genealogy is then utilized by law enforcement, and I want to know if they follow the protocols and rules, do I need the genetic genealogy information that, like you produce as a forensic genetic genealogist? Do I need that information so I would know?
If you wanted to know what the process was, whether or not there was work product, if you wanted to verify how did you come to your conclusion, absolutely.
How about if I wanted to know what the rules were present?
You would need the data. You would need to see the data.
Just a second, while I check my notes. I do have another question about another database, MyHeritage. Is that one that law enforcement uses?
Many in this industry have been known to upload to MyHeritage. Essentially, these databases, you're only bound by the terms of service. And there are workarounds in every one of the databases that somebody knows about and has told you about, or you yourself have tried. There's really no justification for it. You think you're doing the right thing, you want to help, and
There's a lot of information in genetic genealogy.
there is. It is a very tedious process. There is a lot of time, effort, and work that goes into it. In the end, what I provide to law enforcement is an investigative lead, and it is up to the agency to then take over their case and confirm that my lead is in fact correct.
How does law enforcement upload to MyHeritage?
So the upload to these databases is, you go to the website, you create a free account, you take the data file, you hit upload, and voila, you've got now a list of matches. It's the same as a regular consumer would do in both MyHeritage and Family Tree DNA. GEDmatch law enforcement uploads now through a separate portal called GEDmatch Pro, but there are instances of people doing work on behalf of law enforcement uploading to GEDmatch through the consumer portal as if it were a consumer kit.
Thank you. I don't have any other questions. I'm not sure if prosecutor does.
for certain causes of action, Your Honor.
Okay, thank you. This one must be excused. Yeah, thank you, Ms. Vargas. Appreciate you.
Your Honor, our last witness is Vicka Barlow, and I think she's probably in the small library.
Oh, I'm sorry. Okay, I thought that was quick. All right, so you're Ms. Barlow?
Yes,
Please come forward.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
And just seat there and just state your name and spell your last.
My name is Vicka Barlow. I'll spell both names. B as in boy, I-C-K-A-G-A-R-L-O.
Thank you. Ms. Taylor?
Thank you. Good afternoon, Ms. Barlow.
Good afternoon.
What city and state do you live in?
San Francisco, California.
What is your occupation?
I'm an attorney and consultant.
Are you a licensed attorney?
Yes, I'm licensed in the state of California.
I want to talk a little bit about your education to get you to become a lawyer. Did you do a bachelor's degree?
Yes, I have a bachelor's degree in genetics from the University of California, Berkeley.
Did you also get a master's degree?
Yes, I have a master's in genetics and development with minors in plant and molecular biology and cellular biology from Cornell University.
And then you went to law school.
Yes, I did. I attended the University of San Francisco School of Law.
All right. Do you utilize both parts of your education, your law degree and your master's in what you do?
Yes, actually I began using it when I was in law school and was hired in Alaska to assist in the case of DNA evidence back in 1993. So since that day, I've done almost primarily DNA cases.
You were in law school when that happened?
Yes.
Have you done any teaching?
Yes, I teach attorneys regularly. We have credits to keep their licensure, and I also occasionally teach for a guest presenter in law schools around the area.
When you teach lawyers, what kind of topics do you usually teach about?
Oh, 100% about DNA evidence, and it's ranging from the DNA 101, the basics, to the most sophisticated aspects, including things like mixture interpretation, and now the application of probabilistic genotyping in the book.
How long have you taught lawyers about DNA?
I think the first time I presented was probably in 2000. So going on 20 years.
Do you still do cases and represent clients as well?
I've pretty much given up direct representation of clients. I find doing DNA cases takes up most of my time, and it's feel better for the community as opposed to.
What professional organizations do you belong to?
Right now, I think I'm a member of the National Association of Criminal Defense Lawyers and the California Association of Public Defenders, I believe. And I used to be a member of the American Academy of Forensic Science, but I no longer.
Have you authored any articles for publication?
Many years ago, an article that I was a co-author in was published in the Plant Cell, which is a scientific journal regarding the work I did on my master's thesis. And I did also an editorial piece in USA Today many years ago.
Heard you say that you work as a consultant. What does that entail?
Well, I've worked with lawyers who have cases that involve DNA evidence, and a lot of my work with those lawyers involves literally teaching them about DNA, because many people don't have any knowledge about it. That's why they're lawyers. And I sit with them and explain what they have. I read the discovery in their cases, and then I generally, depending on what the needs of the team are, or the particular lawyer, I will help them work on defense strategy, discovery issues, preparation of motions. I write motions. And I also do trial work. I do hearings like this as the lawyer, not as a witness. And I participate as a lawyer in the trials.
How did you end up helping in Mr. Kohberger's case?
I believe that either you or his lawsuit reached out to me.
And what is your role?
I'm my understanding is I'm assisting in essentially understanding the case, helping to do discovery, and consulting on, right now, discovery issues.
In that capacity, have you helped us understand what we have and what we don't have with regard to DNA evidence? I hope I have.
I was allowed access to, I guess, the vast majority of discovery, and I believe that, and identified areas where discovery was missing and where I didn't need to get more information.
I want to focus a little bit on one of the areas of discovery and why it's important to have an area of discovery. I want to talk about DNA profiles and what happens. In our case, there are 3 other unidentified male profiles. What are we missing?
Well, I believe at this moment we have all of the reports of the testing from the state of this laboratory. What I believe was requested and what has not been produced is any direct information or documentation of whether those profiles were uploaded to the state or federal nuclear offender those databases.
I want to talk a little bit about the police data.